Hello, I'm Dave Graulich. I am a solo practitioner here in Sacramento, and today we are at the Sacramento County Public Law Library. And for the next 90 minutes, we're going to be talking about workers' rights in California, the 5 fundamentals. I want to start by thanking Nora and her terrific team here at the Public Law Library who have made it possible for us to get together today. And I'm going to welcome both those of you who are watching and those of us who have joined here, that we can be together. And actually, one of the highlights to me of these sessions is your participation, both your questions and your comments, but also your stories. We've all had jobs, we've all had bosses, some of us have been bosses, and I really welcome you to participate and tell me about your experiences in the workplace. And I just ask that you don't mention personal names and you don't mention company names because this will be public record. So please just do some the disguises of your stories, but beyond that, I really welcome your participation. Okay, then let's get started. This is the core of what we're going to be talking about today. And I've decided that we have 5 cornerstone subjects that apply to the majority of workplace law. We're going to be talking about at will, 2 little words, but enormous consequences to who we are in the workplace and our relationships with our employers. Number 2 is employee or independent contractor. There are people who are in practice, they can make a whole career out of this issue, both on management side and on plaintiff side. Number 3 is exempt or non-exempt. This is going to get us into some very profound issues involving overtime, rest and meal breaks, and some other very core issues in the workplace. Then number 4, we're going to move more into the legislative arena and look at the organic act that influences most of our relationships in the workplace, and that's known as FEHA, the Fair Employment and Housing Act. We're going to be looking at this legislation and its consequences to us in the workplace. And then finally, fundamental number 5 is the concept of wrongful termination. That's a phrase we hear a lot. It gets thrown around a lot. In fact, it has a rather narrow and very specific legal meaning. And we're going to be looking at exactly what that is. So before we get to the 5 fundamentals, I want to do a little prequel and just put in context this field of law that we call employment law. Now, our focus today is going to be on private sector employment. So we're going to be looking at Fortune 500 companies and publicly owned companies and the relationship in the private sector. Our focus is going to be California law. I'm a plaintiff's attorney. My perspective is going to be that of the individual employee, but I am trying to be even-handed. We'll talk about management side perspectives. Some of you practitioners may be management side, and I would welcome your input as well. We won't be talking about the unionized workplace or collective bargaining relationships. I won't be able to cover public entities today. Federal law, we're going to mention it here and there, but that won't be our focus. We won't be covering workers' comp, which is very much of a realm within itself. And we won't be covering unemployment benefits and relationships with the EDD. But believe me, we're going to have our work cut out with us with just talking about private sector employment in California law. Now, what do we mean by this phrase, employment law? Sometimes you'll hear it used interchangeably with the phrase labor law. Now, would anyone want to take a try at is there a difference between employment law and labor law? Does anybody want to try to differentiate between those two? Yes, ma'am.
Well, I think when you deal with labor law, a lot of times you're talking about unions, whereas employment law is other things that the unions would not participate
That's right.
in.
That's right. Employment law is the broader term. Labor law is generally specific to the collective bargaining situation. So you're representing a labor union, its relationships with management. Now, employment law is actually a relatively recent development in our jurisprudence, especially when you compare it to property law, which goes back to ancient England and torts and contracts. Employment law is a relatively new field, and many of the core cases go back to the FDR era and the New Deal. It's expanding very quickly, this field, because more and more of the public policy issues are now moving into the workplace. And the things I deal with week to week not only involve money, but actually it's not only about money. It's going into a whole range of social and cultural and behavioral issues that we bring into the workplace. It's one reason I find this a very fascinating field to work in. Can anyone identify for me who those two gentlemen are? This gentleman, yes.
Former lineman of the Miami Dolphins.
Lineman of the Miami Dolphins, which is a professional football team. Why do I know, why am I interested in them? Can you give me any background?
Well, the gentleman on the left is accused of harassing the tackle there on the right. Guy played at Stanford to such a degree that he left the team and, said that it was a hostile work environment.
Yes. The gentleman on the left named Tony Incognito. The man on the right is Jonathan Martin. They're teammates on the Miami Dolphins football team. Mr. Martin left the team. He did not speak out directly, but his spokespeople said that Mr. Incognito was engaging in severe harassment, including racially offensive remarks, both in the locker room and on the field and outside the field. And the question arises now, what are the social norms at work? And do different workplaces have different norms? Are we going to hold professional football players to a different standard in the locker room than we would hold each other to in an office? And an interesting footnote here, Jonathan Martin on the right, his mother is an attorney, and she practices employment law, and she works for a major corporation in Southern California, and she has published widely on harassment in the workplace. So that's quite a coincidence. I use this just as an example of the kind of fascinating issues and social and cultural things that we're going to be delving into by means of employment law. Now, where does employment law come from in the US? Because I told you that it was a relatively recent development. And we can trace a lot of it back to the late 1800s and the development of the railroads. And of course, Sacramento, our hometown here, has a crucial role in the development of the railroads. But it was the first time that we see the beginnings of large corporate structures, of managing vast amounts of men and materiel, of an employer-employee relationship with vast numbers of people. And it actually was the American Civil War where we learned how to move hundreds of thousands of people around and clothe them, feed them, supply them, give them horses and mules. So that was the employer-employment relationship. In the late 1800s, we had the beginnings of the American labor movement, many of the great stories from that era. And of course, the New Deal, in which the federal government got involved in regulating the workplace, both in terms of pay, safety, and other regulations. Can anyone tell me who these people are? Anyone recognize them? Excuse me, this gentleman over here. Who are these people?
The people from Mad Men.
And what is Mad Men?
It's about an ad agency in New York in the early to mid 1960s.
Right. Has anyone else? It's a great show. Has anyone else seen this show? Well, it is about an advertising agency in the early 1960s, and it captures the workplace mores and culture of that time. And the reason I use that headline is I don't think things have changed a whole lot since the era that Mad Men depicts. We don't smoke cigarettes in the workplace. We don't tend to have fully stocked bars on our offices. I think people in this era probably dressed a heck of a lot better and more elegantly than we do today. But otherwise, the show depicts the interpersonal relationships between men and women, between people of the majority ethnic groups and minority ethnic groups, the hierarchy of power in the workplace. And I look back and I say, boy, it's been 50 years and not a heck of a lot has changed. If you haven't watched the show, catch it. It's really a terrific program. Now, another sub-theme today is going to be, we can't ignore the larger economic reference of the workplace. And I don't think I have to tell you, this is a terrible, terrible market for people seeking jobs. And that plays out in the workplace because there's an imbalance of power between those who are employing people and employees. The job market's incredibly adverse to working people. It's very, very tough here in California. Personally, I don't think it's going to be improving in the foreseeable future. And that has really huge ramifications for those of us in the day-to-day workplace. There are a lot of economic statistics, but I think this chart just tells you about where have all the jobs gone. And we have more and more people, men and women, who are just given up and are out of the workplace, which means those who are remaining in the workplace and have jobs are worried about those jobs, have very little or no job mobility, and are going to have to deal with things in the workplace, adversities that otherwise they could walk away from, which means our ability to litigate and bring these things into public policy and bring these things into the realm of law become more important than ever, because people need that protection and people need somewhere to turn to respond to the adversities of the workplace. So with that as a prequel, let's move on now to fundamental number one, and that's the idea of at-will employment. At will. The code is promulgated in Labor Code section 2922. You can see the code. It's generally boiled down to those two little words, at will. In a nutshell, here's what at will means. You can be terminated at any time for cause, for good cause, for bad cause, or for no cause at all. Now, people sometimes come to me and they say, well, I got a great progress review in March. Terrific review. They couldn't rave enough about me. I got an X% increase. That was in March. And in June, I was fired. How can they do that? And the reason they can do that is because in California, the default is that we're at-will employees. So you can be terminated at any time. But the flip side is you can also change your jobs at any time. You can leave at lunch and never come back. And you can text in a two-word text that says, I quit. And that's the end of it. So it works both ways. Now, it's easy to look upon at-will employment as a very severe, harsh, Darwinian kind of relationship. Because you think, isn't this wrong? I could put in 10 years with corporation XYZ, and any given day I show up and I'm fired and I'm gone. That's true to a degree, but I actually like at-will employment. As a workers, employees, attorney, I think at-will is a good thing, because it means we've created a free market for employment. And let's give management some credit here. We are rational economic animals. If someone is a good employee, someone is hardworking, if someone produces, there's no incentive for Mr. Bumstead to just kick Dagwood out the door. I mean, we want to retain and keep good people. Yes, sir.
But that assumes that there's more equilibrium in the market, right?
Yes.
I mean, that at-will policy works when the number of employers matches the number of employees seeking jobs, right?
Correct. Correct. And the point is a very significant one. At-will is predicated on an assumption that there's something close to some kind of efficient market in the workplace between those seeking jobs and the jobs. When that equilibrium is out of whack, at-will becomes more risky. Now, you can go up to North Dakota, and there's more people who are trying to hire than there are people providing jobs. And you have people getting $25 an hour to work in McDonald's. Our environment in California, though, is the way you describe it. There is no equilibrium, and employees basically have almost nowhere to go. So at-will does become a more Darwinian, ruthless, adversarial situation. Now, ideally, at-will is part of what's helped make California historically a growth economy, because we believe in a free market for enterprise and for labor. You're a worker, you go out and you sell your skills and abilities and ambitions to the highest bidder or where you want to work. Now, there's a related concept about non-compete clauses. Let me throw this question out. You show up, I'm Bob Boss, and you show up, and I put a document down in front of you, and I say, this is a non-compete clause that if you ever leave here, you have to commit that you won't join a competitor, you won't work against me. And either sign this or take a hike. Is that legal? Do you have to sign? Anybody want to take a guess? Sir?
It's void against public policy from what I understand. You can't do it.
It's a violation, correct. It's a violation of public policy. Non-compete clauses are void and unenforceable in California. It's a little different if you're a business owner and I'm selling my business to you, because you can then ask that I don't compete against you because you're protecting the goodwill of the business that you've just acquired. Same with a partner leaving a partnership. Those are more equity situations where there's a residual goodwill after the transaction. But if you're strictly an employee signing in, you cannot be forced to sign a non-compete clause. And this gets real interesting because it underlies what we've enjoyed in California with a high technology society, in that people will leave Intel. People from Intel left from National Semiconductor. People leave motherships like Hewlett-Packard and Genentech, and they join startups, and they get venture capital funding, and they compete against their former company. Sometimes they cooperate with their former company. It's a complex, multi-leveled relationship. Sir, did you have a comment?
Question, well, I mean, there are trade secret clauses, though, that go with this. It's not a complete, blank slate that you can just go join a competitor and
Correct.
Take your client lists or do all these there's restrictions on this.
That's correct. That's sort of a first cousin issue in that that's intellectual property, which could range from patents to proprietary information to data about customers. Now, you can compete against me if you leave me. You just can't take my proprietary information to do so. And that's a trade secret intellectual property issue. And there's tons of litigation about that. But your point is correct. So we're going to leave at will now, but I just want to leave you with these thoughts, and that there have been a lot of carve-outs from at will and exceptions and therefores and maybes. And there are management side attorneys who will tell you that at will has been emasculated and the exceptions now actually outweigh the rule. I disagree with that. I think at will is still very much alive, particularly, as this gentleman said, in a bad job market where the equilibrium has been disturbed in favor of employers. There's an urban legend that you hear people say that it's impossible to fire anybody in California. Has anyone heard that? I mean, yeah. It's not true. People get fired every day in California, more than I wish was necessary. The idea, though, is it's like any transaction. If management follows good practice and good process, documents it, they're less likely to be litigated against or have it voided. But you can fire at-will employees in California. It happens every day. Yes, sir.
Before you leave this, oftentimes in those contracts it says if you're dismissed or you have to go through arbitration, and then thereafter, I guess, proceed with litigation if you choose to. Does the arbitration then take away the right to litigate in court?
I wish I had a simple answer to that, and I don't. It's an immense area of litigation right now, that it's binding. There are counter-arguments that it shouldn't be binding because the bargaining power of the two parties is distorted and you're agreeing to arbitration, and therefore the pistol to the head theory. There's a lot of conflicting court decisions, and my answer really is I don't know. And it's very fact-specific and case-specific. I think it's regrettable that in order to get a job, people are being induced to sign away part of their rights as citizens. I'm sorry, was there another comment here? Okay, so let's say goodbye to at will for the moment. Move on to fundamental number 2. Are you an employee or are you an independent contractor? And just out of curiosity, do we have any attendees today who have worked as independent contractors either currently or in the past. It's common among the writers, artists, photographers, but it's more and more prevalent now, pervasive in the workplace. Companies are shrinking their core employment back to a very small number and then trying to outsource and use independent contractors as much as possible. For example, Apple Computer in Elk Grove has a plant, and they have a very small core employee group, and then they'll rotate people in, keep them for about a year to do the work, and after a year, those people will be discharged and a new group will move in. So the independent contractor issue has moved from kind of a peripheral thing that's specific to craftspeople and artists and people coming in to water the plants. It's actually now, from a corporation's viewpoint, a strategic imperative because it's a way to reduce costs and reduce the commitment to the number of employees. What happens, though, is that it sometimes gets into that ambiguous gray area as to what is the individual. Is that individual an employee or an independent contractor? I've had people call and they experience what I call EDD shock. Can anyone tell me what EDD is? Ma'am, do you know what EDD is? Right. It's where you go in California to get your unemployment benefits. Right, disability. People will get fired from a job. Goodbye, you're gone. So they'll apply for unemployment benefits. They say, well, I've been fired. I wasn't fired for misconduct. I didn't do anything wrong. I just got fired. They'll apply for benefits, and the benefits are denied. Well, what do you mean they're denied? And that's when they find out, well, you're denied because you weren't an employee. You're an independent contractor. It's like, what do you mean I wasn't an employee? I went to work every day. I mean, I had a swipe card. I ate in the cafeteria. Of course I'm an employee. Legally, you could do all that and still be an independent contractor. So where do we distinguish between the people who are employees and the people who are contractors? Did you have a comment?
The ones that have the holdings, the ones that are reported versus 1099 versus W-2.
Okay, so one observation is how you report your taxes. Okay. Now, a couple of thoughts on that. One is, if you haven't reported your taxes yet, if it's within the tax year, so that remains ambiguous simply because you haven't filed yet.
Is an employer required to report quarterly?
Well, are you saying now the individual has
The
filed?
employer is reporting quarterly on their employees and the wages that are being paid.
Okay.
Then, or even if the employee is receiving a paycheck and there are withholdings, that would lead me to believe that they're an employee versus just a check without any sort of withholdings.
Okay. That's a good indicator, and that's going to be one of the factors we're going to talk about. But what we're going to discover is that there are no single factors that include everything, decide everything. It's going to be what lawyers call the totality of the circumstances. Not, when you're a lawyer, you get to use these wonderful, the totality of the circumstances. And another issue that you raise is that you have IRS rules, which is federal, and then you have labor rules. And the IRS, they have a different regiment for independent contractor employee than we have in California. So bottom line is you are right, that's an indicator and that's a factor, but it's not the end of the story. And if everything else is over here and the tax is over here, everything over here will prevail. So a key phrase here, if you're in this area, is going to be the Borello factors. Borello factors. This is the case from 1989, which the bottom line here is saying we're going to look at everything because what's important in this area of law is the day-to-day reality of what people do and its conduct. We're not going to just come up with a list of rules and in a clinical way apply the rules. And it's kind of refreshing because courts can kind of get very abstract and very kind of out there. And here, finally, they're saying, well, let's look at the reality of people going to work every day, the relationships, what they do, what they don't do. And based on that, we'll come to a decision. Are you an employee or are you a contractor? The key concept here is control. Control. Who has the control over the individual? Now, when I was a freelance writer years ago, so I'd get a project and I'd sleep in till 11 o'clock or so, and I'd slowly wake up, I'd have coffee, I'd go out and I'd have lunch around 2 o'clock, and then I'd read the newspaper, and then maybe around dinner time I'd start working on my project. So I had control over my day, and I was an independent contractor. It's a different story if I had to be at Bank of America at 9 o'clock and attend meetings at 10 and go by their regiment. So a lot of what we're going to be talking about, employee versus independent contractor, is this concept of control. My control over your time, my control over your work, my control over your tools. I put this in your take-home, and you can look at this on your own time, but you can see we have 11 factors here. You don't have to memorize these. The point I'm trying to convey is that this is a complex issue. And when you litigate this, I come in with my basket, and you come in with your basket, and we duel it out. And I'll say that, well, my client had to wear your uniform and he had your business cards. And then they'll say, yeah, but he didn't have to be here every day, and he had other companies that he worked for doing the same thing. And then I'll say, well, the other companies he worked for, he wasn't doing what he does for you. That was unrelated to this. And back and forth and back and forth. It's actually, it's an interesting case. Do we have any litigators here today? Do we have any trial attorneys? I find this as kind of a fun realm to litigate in, because it's very fact-based, it's very specific to the case, and it's anecdotal. You can really delve into things. So it's often my bundle of facts and examples and anecdotes versus yours. And the one who is more persuasive is going to carry the day. So I think we're pretty much done with fundamental number 2. But again, what are you and what is your relationship with your employer? It's a big deal. Now we're going to move on to fundamental number 3. It's the concept of exempt versus non-exempt. So my first question is, that gentleman in the little picture there, does anybody recognize him? Who is that man? Ma'am, do you know who that man is? Okay, Steve Carroll's an actor. And do you happen to know what part he's playing in that?
Michael Scott.
I'm sorry?
Michael Scott in The Office.
Okay, The Office, which is, and what is The Office for those of us who don't know? Can anyone describe what The Office is? Can you describe The Office?
Yeah, it's just a small paper company, and he's kind of a ridiculous boss.
Right. And he's basically a twerp, right? I mean, he's the. It's a very funny show, and it takes place in current times. Now, exempt versus non-exempt is it's actually painful to talk about, because to me it smacks of a lot of socio-economic elitism. It's a holdover from a different kind of era. It's something that's out of sync with us in the 21st century. But exempt means that you are exempt from the California laws having to do with overtime, meal and wage break, and other laws that protect the hourly workers. You're in this lofty area up in the clouds called exempt. And we associate exempt with management. We associate exempt with people who use their minds and their creativity and do professional and managerial tasks. So non-exempt is everybody else. And there was an era where the person on the assembly line who was bending the metal using muscle was non-exempt. And the person sitting in the office who was thinking about how to advertise that piece of metal, or what design it should have, or what fancy name it should have, and using intelligence, that person was exempt. And it just doesn't apply today. It really doesn't apply, and that person on the assembly line is probably using a programming language with robotics equipment and is making other decisions and is running a small workspace as opposed to just methodically doing assembly line work. So nonetheless, we are saddled with this. And we're going to have to figure out a new regime going forward, because this is kind of silly, and it divides us in ways that we shouldn't be divided. That's my editorial comment. Fact remains, this is the law as it is today. So we have people who are exempt, and then people who are non-exempt. So those would be technical people, craftspeople, workers who are on the hourly regime. And intuitively, we think we know who is exempt and non-exempt, but there have actually been some very interesting cases about professions or people in jobs that you kind of think is managerial and exempt, but in fact the courts have said that they aren't. An example of this would be mortgage brokers and people who arrange your loan. And you think, gee, that's a complicated job, and they're doing insurance and interest rates and all this kind of stuff. And they don't get, some of them weren't getting paid overtime. And this went to court, and it said, you know, they're more applying an application to a set of rules. They're more matching up incoming information with a set regime, and either saying it matches up and you get the loan, or it doesn't match up when you don't get the loan. So that it was, they were non-exempt. Another example is insurance adjusters. There's been, you might be familiar with this, sir. There's been a lot of litigation about people who come out, you have a car accident, you have a dent in your car, and this person comes out and takes pictures, and you think, this is a white-collar managerial thing. I mean, they're making big decisions about the repair of my car. And this has also been litigated, and it's been found that these people are non-exempt because, again, they are applying a set of data to a set of rules, and they're seen as being transactional as opposed to actually using discretion and independent judgment. I think this is all kind of silly, myself. And I mean, I think we all use our minds and we all use independence and discretion in the modern workplace, but we are stuck with this old regime. So why does this matter? So the question becomes, who is really a manager? Because you have the title of manager. Now, I think I might be either the oldest person in the room or one of the oldest people in the room. Can anyone tell me who this man is? Does anyone know? Sir?
Casey Stengel.
Yes, it is Casey Stengel, who was manager of the New York Yankees and went on to be manager of the New York Mets, and he was a manager well into his 80s. And I put Casey up there because there's a psychological aspect at play here, because there's a certain aura around the word manager. We all want to be managers. I mean, being a manager is pretty cool. Manager means you're part of management. I mean, you're part of that lofty thing, and we aspire to that title. We're kind of proud of it. We like having a business card that says manager. And that creates a problem, because if the reality is that our job is not a manager's job, and we're basically working overtime doing non-exempt tasks without getting paid overtime, that's wrong. But that means admitting that we're not really a manager. And a lot of us don't want to do that. So we want to be a manager, so that even if it's being taken out of our pocket and we're being put under a workplace regime of extreme duress, heck, we want to be managers. So what ultimately defines who is a manager? And a lot of it comes down to this statute: discretion and independent judgment. Discretion and independent judgment. So again, the idea is if I'm just mechanically doing the same thing every day, following rules, going along, just moving stuff like I'm supposed to do it, opening those iPad boxes, breaking down the box, taking out the iPad, scanning it, sending it on, I'm not using discretion and independent judgment. If I am, that makes me a manager, that makes me exempt. I always look at this and I say, who has a job where you're not exercising discretion and independent judgment customarily and regularly? I mean, every day you show up at work, I don't care what you're doing. I don't care if you're taking coins out of the vending machine, using independent judgment. Nonetheless, this is the statute and this is the golden standard. Just take a 30-second interim here. Does anyone want to jump in on this? I mean, does any, yes, sir.
Did the president recently speak to this, the independent manager, or the independent, the exempt, the non-exempt person, that I think there was a complaint that the exempt person was working many, many more hours and not getting compensated for it. And really the benefits that are supposed to go with an exempt position aren't really materializing. And the employer is getting all the benefit because he's not paying the extra pay that he would be required to pay if this person was being paid an hourly wage versus a salary.
Did President Obama speak to this?
I
Yeah.
think so.
Okay, I'm not familiar with that. I know there was something on the federal level called the Lilly Ledbetter Act. I wouldn't be surprised though, because it's a huge issue. And, yeah, but on behalf of management, I think we've all inherited a really outmoded and inefficient regime of exempt versus non-exempt. And we're all struggling with it, and management struggles with it too, and I think there are inadvertent mistakes made. Yes, ma'am.
Are employers not informing new employees about what their status is? Because there's a lot of like people who would be non-exempt who may not understand what exempts do. They understand you go to work, you get paid an hourly wage. If you work overtime, you get overtime. If you work holiday, you get double pay. Are there a lot of employers out there who aren't telling their new employees, you can't work overtime because we can't afford to pay you, and they're not making that distinction to those folks?
The question is, are there a lot of employers that are not communicating correctly the rules, and that people who are exempt or non-exempt understand the guidelines? Before I give my thoughts on that, does anyone else want to take a whack at that? Does anyone else, based on their own experience? I think it's multi-level. Number one, I think there's a lot of good faith effort to explain it. I think people end up being confused anyway. When I talk to people about exempt or non-exempt, it's very frequent for people to say, what do those mean? I mean, which one am I? I mean, exempt from what? I mean, they're fuzzy terms, and a lot of people just don't know. Secondly, the rules can be complex, and I think well-meaning people sometimes make mistakes, both on management side and on employee side. Thirdly, there are companies that use this antiquated regime to their advantage, and it's part of their business model, which is number one, you promote people to exempt, so you give them the trappings of exempt, but you work them like they're non-exempt. You don't pay them overtime, and you basically exploit them by making them exempt. On the other side, there are people who are non-exempt, and they get warned, don't work overtime and don't break the rules, but there's no adjustment in their workload. So they're expected to get everything done within 8 hours, and it's impossible. They're told that don't work off the clock, that's wrong, but it's kind of like, say, an insurance adjuster. They've reduced the number of insurance adjusters from 8 people to 3 people. There are only 3 of us. I have more work to do. I have to keep up. My performance is based on my keeping up, but then they tell me don't work overtime. So there's more work. I have the same number of hours. What am I supposed to do? I'm sneaking work home in my briefcase and working on it over the weekend and not telling anybody, so that when I come in on Monday, I have the work done. I think there are companies where it is a conscious part of their business model to exploit people and to use the rules to their advantage. That's been my experience. Does anyone have personal experience with that, or want to just jump in? Say, has anyone here been made a manager, but basically had to survive on non-exempt rules? Has anyone had that experience? This goes to your point about, are people confused, or are things communicated correctly? With the exception of the last one, these are actually verbatim things that I've heard from people when I talk to them about when they're exempt versus not. I got a little creative on the bottom one. For example, the title doesn't have consequences. I can give you whatever title I want, but if I create your workday that you need to do 11 hours work a day and I'm only paying you for 8, it doesn't matter that you're a manager. We'll drill down in a moment, because it's not only the number of hours you put in, but the nature of the work you're doing during those hours. So we're going to get to that in a moment. But there's a lot of misperception about if you're exempt or if you're non-exempt. Incidentally, I might have you sign a paper saying that I'm exempt. I agree, I'm exempt. Going back, I might have you sign a paper that says, I am an independent contractor. I agree, I'm an independent contractor. That is not conclusory. What those papers that you sign will be another bit of evidence. It goes to the weight of the evidence and not the conclusion of the evidence. And that makes sense from a public policy viewpoint, because again, it's the pistol to the head concept. I need a job. I'll sign whatever you put in front of me. Put in front of me, I'll sign it. So if I force you to sign something that says I am an independent contractor to get the job, that can't be the ultimate consequence at the end of the day, and I'm glad to report that. Sir, did you have a thought?
Just very briefly, I'm wondering what besides the employee, I've never been a manager. So for the employee, besides that he or she can say I'm a manager or a management, it doesn't seem like there's any benefit. I mean, it seems like the benefit's all on the side of the employer. So on my business card, it says I'm a manager.
Yeah.
But I'm here until 8 o'clock at night.
Right.
I don't get paid anything extra. Or,
Right.
Or they can call me on the weekend and I'm supposed to be thinking about that issue, even though I'm at the theater or something.
Right. Do you read Dilbert? You know, the cartoon strip Dilbert. Yeah. So the question is, in economic terms, is there a real benefit to being a manager? I mean, is it an illusion? Is it actually is one of these things? Now, I think we've all known people who were working on hourly and made overtime, and they say, I don't want to become a manager because I'm earning overtime. I have a better situation here. I'm running away from being a manager. But I have an answer, but does anyone want to answer the gentleman's question? Why would you want to be a manager? Are there economic advantages to being a manager?
Certain jobs, there's more pay if you're a manager.
Okay.
Higher pay is offered.
Bonus. Sometimes there's a bonus pool for managers. Sometimes stock options are limited to managers. Sometimes there are other perks or economic benefits. I think the biggest thing is that basically is the career track. If you have career ambitions over a 15 or 20-year curve, you have to be on the management track. I think a lot of people have a dilemma where they're research scientists and they love being on the bench, they love being on the laboratory, they're in the semiconductor industry and they're scientists and engineers, but they think I have to get on the management track if over the long term I want to do well. So I'm going to stop being someone who does this well, and I'm going to become a manager of a family of people who do what I wish I was doing. I'm going to spend my time being administrative and pretending to be Steve Carell. It's a dilemma. Now, I misspoke a little bit earlier when I was talking about hours, just sheer number of hours put in on the job. Because saying that I'm working 10 hours or 11 hours and that makes me a manager or non-manager, that's really not correct. We have to drill down and look at what are the nature of the tasks that you're doing during those 8 or 9 or 10 hours. And there's one family that's considered the managerial tasks, and there's one family that's considered that of an hourly employee. And we basically say, which one are you doing more than 50%? The more than 50% rule. I had a case involving a retailer. It's one of the retail chains where everything is at a single price, a single low-value price, $1. And they would create people as managers, and congratulations, you're now the manager of my Fair Oaks store. But they were incredibly stiff on not allowing them to have labor hours, so no overtime, very tough on hours, very tough on the number of people you could have in the store. So the person's there busy being a manager and training and hiring and firing. Okay, well then a delivery truck pulls in with your new load of candy and items. Well, your only other employee is cashiering, so guess who gets to unload the truck? Guess who gets to put the stuff on what's called a U-boat and roll it into the store? Guess who gets to put it into the warehouse and put it on the shelves? Guess who gets to clean up the bathroom and so forth and so on? Well, it's the manager. And this litigation got then involved in what are these people really doing day to day more than 50% of their time? And it gets almost down to the minute what people are doing. And ultimately, it's a binary decision. More than 50% management, your company's fine. More than 50% doing non-exempt tasks, you're being exploited. And again, it's an interesting type of case to litigate. And there's a lot going on in this because it becomes very fact-specific and really down to the nitty-gritty of what people are doing almost on a minute-to-minute basis. very common in retail, corporate chains that have retail that are very tough on labor costs. Some of them are East Coast companies that come into California, and they're not used to our labor laws. There are some more tolerant laws back east, and they really run into problems. Just, has anyone worked in retail here in California? A dollar store, Burlington Coat Factory, rentals, things like that? Anyone have that experience? Okay. Very, very common source of litigation. Unfortunately, a lot of exploitation of calling people managers, giving them non-management tasks more than 50% of the time, and thereby not paying them overtime. I'm very proud of this slide. I really thought this was my top creative effort of the week. California recognizes 8 professions. And the idea is that if you're in one of these professions, you are exempt and you don't get overtime. So you'll see the 8 there. So I created, I think, a very clever mnemonic. T a la mode. Isn't that good? Well, all right, you don't look very impressed. I thought it was very clever on my part. But if you're in one of these professions, you don't get paid overtime. And those of you who are lawyers know that if you're up till 2 in the morning at your office working on a brief or a discovery, you don't get paid for that. You don't get paid for all those hours you put in because you are a professional. Congratulations. You can work exorbitant labor and be exploited, and you have to be happy about it because you are a professional. So again, why does this matter? Because if you're not exempt, there are a body of laws that protect you and that apply to you, and that it's a big deal if you are deprived of these things. Now, one is meal breaks, and you're entitled to a half hour. It's unpaid, but it's a big deal that you have to be allowed to take this, and you cannot be intruded upon during this time. So you get your half-hour break, and if your boss wants to come and sit down in the cafeteria next to you and talk about what's going on at work, that's actually wrong. That's an intrusion into your time. Do I think that's a good law? No. I mean, I actually think it's kind of silly that people go off and that we can't all be colleagues and talk about our work and share our thinking. But if you're a manager, you have to allow that person half an hour to go off and have their break. I have a family member who had a temp job working for a medical practice here in Sacramento. And she would get her half-hour break, and she'd have lunch, and then say, well, I'll go back. I mean, I'm done. It would be like after 20 minutes. But she'd go back, and she'd clock and go back to work. Well, she was reprimanded. Why? Because she was clocking in too soon. She was clocking back in and going back to work without taking her full half hour. And it was all clocked. You know, all Big Brother was looking in. They were all getting the printout. And she had to wait till 30 minutes had passed by. I mean, she could sit there, but she had to do something else and let 30 minutes pass and then clock in. Now, as a productive society, do we really want a world where people are forced to linger over lunch and not go back to work? I mean, do we really want that as a society? Probably not, but that's what we got. Sir, did you have an observation?
I was just going to comment that employers were generally forced to do that because they're subject to major penalties if they allow them to return to work before 30 minutes. I'm sure you're going to comment on that about breaker, but
yeah. The comment is correct, and it's that employers, I mean, they're not doing this because they want to mess with people's minds. They're doing this because the consequences are very serious. That if they can't document they've given the people opportunity for a full half-hour break, they face all kinds of fines and they face all kinds of serious consequences. So as a result, you have kind of a lunch break police force that goes around enforcing that you have taken a half hour. And then you get situations where Dave works out in the farthest reaches of the warehouse and I'm wearing protective gear, and there I am, and maybe I'm painting or I'm doing work. Well, now it's my half hour. So I'm taking time to take off all my protective gear. This is known as the doffing and donning rules. And then I have to walk all the way through the warehouse until I get to where I'm going to eat my lunch. So that's a lot of time. That might be 10 or 15 minutes of time. Well, that has to get added to my half hour in the interests of equity, because otherwise Yeah, everyone's finished lunch and I'm still getting out of my protective gear. An enormous source of litigation, and I think it creates a lot of confusion. If any of you have been managers, sometimes it's just like, all right, well, do you get your meal break now, or do you get it later, or like, does the half hour count, or if you stepped out for 5 minutes to help a customer, do I subtract those 5 minutes? Sir, did you have a comment?
Sure, the labor code provides that the meal breaks are dependent on the number of hours that you have to work. And that, I'm trying to remember, I think 6 hours, whatever, a meal break can be waived by agreement between the employer and the employee. And then if you work beyond a certain time, you have to have an extra
Right.
meal break for dinner as well. But, and the labor code says that during a meal break, the language is that the employee has to be relieved of all duties.
Correct.
During that time.
Correct.
So I don't know whether just generally talking about the job would constitute not being relieved of all duties. And then there are provisions in the labor code as well for what we call on-duty meal breaks as well, but they are going to be paid.
Right.
I'm just saying there's some new.
Yeah.
You know.
I know management side people, and when they consult and they advise employers, they take a very cautious line. They say, just hands off. Don't talk to that individual at all. Have that been your experience, that you'll tell people?
If you want to completely protect yourself from, potential liability, that's
Right.
really, that was your mandate. You had to do that. So.
I had a case where it was a company that does rentals, and they would send out a delivery truck and give them a very ambitious delivery route from Auburn down to Elk Grove in one day. And not only would they deliver the appliances and computers and TV sets, they would help the customer set it up and show how to use it. So then they'd have to hit the road and get down from Auburn to Elk Grove or Lodi. Well, their half-hour lunch break meant running through a Subway or Burger King and getting their food and jumping back in the truck so that they could keep on their delivery schedule. Now, was that a half hour of uninterrupted time without, the intrusion of their work? I don't think so. They were running to make their schedule. And if they took a half hour at Burger King, went back on the road, and incurred overtime, they weren't going to get paid because there was a strict rule of not overtime. So the reality is these are unworkable rules. I mean, we're straining under this regiment. There are many conscientious employers who are trying to understand this and treat their people right and observe the rules. But the reality is it doesn't work. You have two people in a store. My colleague is on his half-hour lunch break, and 12 customers come in during that time. I mean, what am I going to do? Can I serve 12 customers? Can I ask my colleague, maybe set your sandwich down for a moment, or you finished your sandwich, come out for the remaining 10 minutes and help me serve customers? I cannot. And if I'm the manager and I make that request, I have violated the labor code. This is the environment we deal with. And again, it's these arbitrary divisions that we make among us all in the workforce between exempt and non-exempt. Okay, rest breaks. During a typical work shift, you're entitled to 2 rest breaks. You are paid for that, and you get 15 minutes. The biggie here, overtime. If you're exempt, part of the management class, you don't get paid overtime. If you're non-exempt, you can theoretically get paid overtime. What's the basic rate of overtime if I go past 8 hours? Anybody know? I'm sorry?
1.5.
One and a half time overtime. In this economy, companies have taken a very tough line. You have to get permission to work overtime. It has to be approved. If you work overtime without approval, you'll probably get disciplined. You'll probably get written up. So the overtime rules originally were very idealistic. And it says, number one, we're going to protect people from abuse where they have to work. Secondly, it's going to create jobs because we're going to make it so expensive to make the same person work overtime that it's going to be an incentive for employers to hire new people rather than pay expensive overtime. Well, as idealistic as those ideas were, they're not true these days because companies aren't making that incremental new hire because it's so expensive. And they're also not allowing overtime. So the phone call isn't getting answered. That incremental customer is not getting served. The additional sale is not being made. It's just, we'll live without because we don't want to pay overtime. We're also not going to hire anybody new. So these rules from the FDR era, which were intended to help and protect the working person, now have swung the other way, and they're just an enormous weight that's impeding growth. This fourth point about working off the clock, again, it's like a Dilbert cartoon. People are told not to work. They are punished for working. I have a job. I'm a salesperson at a retail store. Say I'm in charge of the gift section or the toy section. And I'm very conscientious. I want my section to look great. I want the shelves stocked. I want everything to look great. And on Friday afternoon when I leave, I want it to get ready for the weekend. So I go in off the clock. Maybe I go in early on Saturday. Maybe I go on Sunday night. And I work my section. I want it to look great. Good thing, right? Wrong. I get fired. I get fired because I'm working off the clock. Managers will sit in the parking lot waiting to catch me going in. Where are you going? Going shopping at Safeway. No, you're not. You're going into our store and you're going to work your section to make it look better. Working off the clock is a punishable offense. You can be terminated for it. Now, why do companies do this? Not because they're bad people, because as this gentleman said, there are very serious legal and financial consequences if people are working off the clock. So we have one of these bizarre situations where management has an incentive to not let people work and not let people be productive. I'm going to touch briefly on the realm of class actions. Sir, yes?
Sorry, question. Overtime and working off the clock were obviously enacted to combat abuses where people were being forced to work longer than they were being paid or forced to being worked when they weren't paid. And you seem to indicate that you think that they've outlived their usefulness. What would you propose to replace those and still counter the abuses that they were enacted to prevent?
Okay, one policy change I would like to see is that if you consensually work overtime, you can be compensated with time off rather than with cash. And I think this can be consensual between the parties. As it is now, you cannot legally do that. And particularly smaller companies, I might want your services in overtime, but I can't afford to pay you time and a half. But maybe if we agree, party to party, that you're going to put that extra push in to get me ready for the Christmas season, I can then compensate you with extra holidays and extra vacations, non-cash compensation. I think that's a policy change. I think we need to revisit the laws. I'm sympathetic to protecting the individual worker, but I think particularly in an information society, the idea of 8 hours of labor and then you go home is just not consistent with the reality of how we work. Is that addressing your point, or did you want to follow up?
No, I didn't want to argue with you. I was just curious what you would have proposed instead of what we currently have.
I'd like to see more bargaining between individual employees and their employers, and the employer able to offer comp time as a form of compensation for overtime. Sir?
It seems that something like that would be very in the interest both of the employee and the employer. Because the large companies always seem to be looking at the bottom line for the interest of profitability, for the interest of how their stock is doing, and having to pay employees or choosing to pay employees overtime or hiring more employees, it affects their profitability. So if that kind of arrangement, like the one you mentioned, might be worked out, then it might not impact their statements that they have to.
Yeah. In addition, from the viewpoint of the employee, I think to many of the people I know, the idea of time is as valuable as the idea of money, because we're taking care of aging parents, we're taking care of children, they have many demands on it. The idea of a week of extra days to themselves would be a very attractive form of compensation. We're at the hour mark. I'm going to suggest that we take a 5-minute breather. If you could be back here at about say, about 23 minutes before the hour and take a little refresher, and then we'll all come back. Okay, we're back. And we're going to finish now with our discussion of meal breaks and rest breaks and related topics. And I want to touch upon the idea of class actions, which have become more difficult. Here's, as a plaintiff's attorney, this is a problem I face when people come in with overtime difficulties, that to the individual, the dollar amounts are small in the litigation context. That $2,000 is a lot of money to me as a person if that's what I think I am owed in overtime. But it's uneconomic, diseconomic to litigate for $2,000. So in the past, I would find a lot of people like you who have been in similar situations and try to create a class and then litigate the class action. So you multiply increments of money, $100, $500, times thousands of people working nationally for a retailer, now you have a big case. And there are law firms that are class action specialists. The tide has turned against class actions. It's more difficult. There was a US Supreme Court case about 3 years ago involving Walmart, which took a tougher line on certifying the class. So all of this is to say that it's tougher for people to get representation when they feel they're out several hundreds of dollars, several thousands of dollars, just because of the economics of litigation. This family of litigation known as wage and hour cases, the great mother of all cases in California went by the name of Brinker. Brinker is a nationally publicly traded company that operates eateries and restaurants. And there was a huge litigation involving meal breaks and rest breaks that ultimately went up to the California Supreme Court. We could devote a whole hour and a half to Brinker. I just wanted to raise the name, and you're aware of it. And if you are working in this field, it's one of those core cases that you're going to encounter. Fundamental number 4 is the core legislation that you're going to encounter in this area called FEHA, the Fair Employment and Housing Act. It's interesting that it's actually in the government code. It's not in the labor code. It is our analog to federal Title VII. California law actually is tougher in favor of employees and often goes beyond federal law, which means that as a plaintiff's attorney, the rule of thumb is I want to be in California courts. In terms of jurisdiction, I want my cases to be in California, not in federal court. Sometimes there's a whole lot of competition and arguing about jurisdiction, with management side attorneys trying to remove the federal, me trying to fight back and keep it in state. Personal opinion, I think a lot of that's overdone. I think there are nuances, and I'm happy to litigate anywhere. I'm not going to spend years of my time on jurisdictional battles, but again, the rule of thumb is plaintiffs want to be California jurisdiction. And DFEH, which is actually here in Sacramento, a very well-run agency, and a very good agency. So some practice tips here. If you're representing somebody who is litigating under something that's been violated in FEHA, you must first exhaust your administrative remedies. And that means getting what's called a right to sue letter. You can either ask DFEH to investigate this on your behalf, where you have a government agency working for you, the individual, or you can say, guys, I want to get my own attorney. I'm going to do private action. I'm going to tell you just what I'm concerned with, but then give me my right to sue letter. Big mistake, plaintiff's attorney, you go to court and you have not exhausted your administrative remedies. Big mistake. You'll get knocked out right out of the box. It's also some nuances in that you have to be specific in your right to sue letter what you want to litigate about. Because if you talk about topic X in your right to sue letter and you litigate on topic Y, they're not going to match up. Big trouble. In general, you have a 1-year statute of limitations to file a civil action. So if you're fired on this date, you have 12 months from that date to file. The nice thing about the right to sue letter that from the day that you get that letter, now the clock starts running again, and you have another 12 months. I think most of us in the plaintiff's bar have had the situation of someone coming in, and it's an interesting case, and then, today's Monday, and you say, well, your 12 months is up like on Wednesday. I mean, it's like, we have 48 hours to make this happen. Or your statute of limitations was last week, which means we're dead. I can't do anything for you. How do you get the right to sue letter? You can do it online. I just have to warn you that the computer system that DFEH has, they call it Houdini, and it's been very buggy. Has anyone here had the experience of dealing with it? Okay. They've had a lot of problems with it. It was revamped about 2 years ago. They're making an effort now to do a new interface and hold it over. Just a practice tip, I tend to log on with my client and collaboratively get the right to sue letter. I could do it myself, but I find it both team building and also just instructive for them to go online with me. Literally sit shoulder to shoulder at the computer and log on. Practice tip that if you're representing someone and you're going to go on Houdini with them, do a few practice runs first and familiarize yourself with it first, because it is buggy and it has some intricacies. And it's not fun to be sitting there with your client with something you're supposed to have expertise in and you're fumbling around. So, and here's hoping that Houdini, if we meet again in 6 months, is going to be a lot better. This is the areas of discrimination under FEHA. It's a very large list. There will be areas that actually exist here that don't exist in federal law. Now, does anyone just happen to know something that is a form of discrimination in California which is not recognized by the federal government? Well, can you be a little more specific?
I think if you're married or not married, sometimes people are discriminated against. They're given extra work, say if they're not married, they don't have a family.
Okay, I don't believe that's true. What I was looking for was sexual orientation, which is protected as a form of discrimination in California and not on a federal level. One side note here, I used to be puzzled by this. There are two categories. One is called sex, and one is called gender. I used to use those two words interchangeably, sex discrimination, gender discrimination. What I found out is there is a significant difference. Sex is it's a biological term. It refers to our anatomy and our genitalia and how we're equipped. Gender is more socio-cultural in terms of the roles that we have as males or females. So sex is if I'm male or female. Gender is the stereotypical role that I play in our culture. It's interesting to see who is within FEHA's domain. If you're a temp worker, you can be protected if you're discriminated against or harassed. Or from a volunteer working the Sunday march for a cure, I am not. Probably it's a good idea that if I work for my father in a family business, I can't sue him for harassing me or discriminating against me. It does not cover if I'm a California company, but I have employees in Colorado and they're residents of Colorado. It doesn't, there's no long arm that can reach into Colorado. Internships, this is an emerging area, the summer internship, the college students, and it's unclear, really, their status. And if you're an intern in the White House, it's very unclear what your status is. So that's an emerging area of law. I'd like to move on now to fundamental number 5, wrongful termination. Wrongful termination. And here you see your key decision, a 1980 case called Tammany. You'll sometimes hear people use that as a generic term. I'm going to file a Tammany action. Wrongful termination, its full name is wrongful termination in violation of public policy. Violation of public policy. And this is where the rubber meets the road. Because anyone who's been terminated can come to you that evening and say, I've been wrongfully terminated. Well, there's a difference between being terminated and it's wrong and wrongful termination in violation of public policy. To litigate under this form of termination, you have to have a public policy. Number one, it's well established. Number two, a nexus between what happened to you and the public policy. There has to be a linear connection. The public policy has to be substantial and fundamental. If you can find something in the outer limits of some very obscure code from 1812 having to do with horses and buggies, that's probably not going to hack it. The courts say that what happened to you it has to be based on a statutory or constitutional provision. There's a case that says it has to be tethered. I always love that word tethered. It's like when you're a kid and there's the ball on the string that you hit the tether ball and it goes around. The violation has to be tethered on a specific statutory or constitutional provision. Article 1, Section 8 of the California Constitution often comes in handy here because it talks about protections that we have as citizens. So the point I'm trying to drive at here is it has to be beyond that feeling that you have been wronged as an individual. You have to say, I went on military leave in the National Guard, and when I came back, I was fired. And that's against public policy because we want people to do military duty. We want people to serve on juries. We want people to vote. These are specific constituencies of public policy, and I can point to them, and I can say, here's the rule that says this is our public policy, and I was terminated because of that, therefore it's wrongful. Sir?
As a plaintiff practitioner, have you noticed a difference in mixed motive discrimination, wrongful termination cases based on the recent ruling that allowed recovery of attorney's fees even when there was no compensatory damage recovery? Recent court ruling last year
Right.
permitted recovery of attorney's fees in a mixed motive case even
Right,
where the
right.
jury found that the fundamental reason for being terminated was a mixed motive, but it was it also there was a permissible motive as well.
So the impact on my practice?
Yeah. Are we seeing more suits based on that, or?
I haven't. I don't think that's trickled through yet. I know that it's a very consequential decision having to do with, would you mind just explaining what mixed motive means? Could you share?
Well, mixed motive generally is where you have a discriminatory reason for firing somebody and a non-discriminatory reason. For example, you fired a pregnant employee, but the pregnant employee also had missed a bunch of days, had been out sick a lot of days. And so the employer says, I'm releasing you because you missed all these days. The employee says, no, you're really doing it because you commented on my pregnancy before you fired me. So therefore, you had a discriminatory motive. And that's what's known as a mixed motive case.
And I haven't seen that come through. So it's I think you're right, though. I think it's on the way.
What if the pregnant employee is missing time because of her pregnancy?
Once again, it's going to be up to a jury to decide whether that
Would
is
that
a
be considered a
legitimate
medical
or
condition?
whether there's a reasonable accommodation that needs to be made or not.
And
Does an employer have the right to have somebody in that position, let's say it's a receptionist at a busy law firm, and they need somebody there to answer the phones, and they have to have somebody dependable? Would there be any sort of penalties involved for letting that person go because they're pregnant and missed too much time from work? And they need to have somebody there all the time?
Well, that's going to, like I said, it's going to be a fact-specific case here where the trier of fact, in this case usually a jury, is going to make a determination as to whether or not it was reasonable for the employer to terminate them based on, we need you here more often, versus we don't want a pregnant lady sitting at our front desk because we think it makes our office look less than professional. And so the trier of fact would make that determination based on the evidence that's given.
I'd love that case, by the way. I'd love to represent that lady if you need her. Let's continue this conversation after 4 o'clock, but I much appreciate the observation, the input. A final note here is if you're going to sue for wrongful termination, again, think big picture. It has to impact on the public. And there's some anomalies here. For example, I go to my boss and I say, I think Dave is embezzling money. And I have evidence and proof. I think Dave's taking money from the company. What I don't know is that Dave and the boss are good buddies. So the boss says, you're fired. You know, Dave's my buddy, I'm going to protect him. And maybe he's embezzling, but okay, take a hike. So I go to a lawyer and I say, I reported this embezzlement and I was fired. That's wrongful termination. I mean, public policy is violated. I mean, we don't want people to be embezzling, do we? Chances are it will not fly as wrongful termination. Why? Because that's specific to that company, that employer, and that employee. And if the guy's embezzling, that's a concern of the shareholders of the company or the partners of that company. That is not perceived as a public policy issue. Now, you might have grounds for things like retaliation. You might have other ways to get that into court, but it is not a public policy issue. Sir?
Does it depend on the kind of employer that you're working for in a case like that?
Absolutely.
Okay.
Okay. If it's a government contractor, if I'm building a space shuttle and I'm embezzling, now I'm embezzling public money. I'm embezzling federal funds. So absolutely, then it becomes a potential whistleblower situation. In the universe of wrongful term, you can have breach of employment contract. Remember, at the beginning today, we talked about at-will employment. Well, if I have a contract to work for you for 5 years under these terms, I'm not at will. I have a contract with you. And if you breach that contract or you try to put me in a position where I can't fulfill my contract, now we're talking about public policy issues because contracts are a big deal. And as a people, we want people to uphold their ends of the contract. And as this gentleman suggested, there is a whistleblower protection when it's a federal contractor. So you're building the new East Bay Bridge into San Francisco, and I report that you're not putting the right rivets in. Well, yeah, public policy, because people are going to fall off the bridge. So there you have it. Those are the 5 fundamentals. I'm going to conclude now. I'm going to make you aware of some other resources that I think could be useful to you. Now, the first resource I want you to be aware of is that if you look around here and when you go down the steps, and that's the Sacramento County Public Law Library. Nora and her team have an incredible resource here. They have an excellent collection of employment law. And even better, books circulate. So you can get a practice guide, you can get an authoritative work here. And if you have a library card, you can take it home for up to 3 weeks. And it's really quite remarkable. They have Westlaw here. They have expert help staff. You're across the street from the county courthouse. So if you're not aware of this law library and you're not utilizing its resources, you're really missing the boat. In your take-home, I pulled these cases for your further reading. They're not necessarily the most important cases, the ultimate cases, but they'll give you the flavor of employment law, and they're very accessible. They tell you stories that will remind you of work. They're situations, in some cases, they're ludicrous and they border on the semi-comic, but they're good cases, and I think it will intrigue you and kind of get you into the playing field of employment law. And this isn't a handout you can take home. If you're in this as part of your business or as an individual, you're trying to find more about your individual rights, the standard source is called the Pink Books because they're in pink binders. They're published by the Rudder Group. Some of the editors are from our employment bar here in Sacramento, some very distinguished people. And they're available here in the library, and they circulate. So they're a terrific source to get your grounding. I'm a member of the California Employment Lawyers Association, CELA, a very superb practice group, and they have a website that has a lot of information. If you're looking for counsel, you can go to that website. You can put in your zip code, your county, your city, and get a list of plaintiffs' practitioners. On the management side, there's a very excellent publication. It comes out by email from the firm Seyfarth and Shaw, and it's specific to California practice. It's called California Peculiarities. It's from the management employer side. It's often written with a lot of wit and humor, and it's a commentary on emerging developments in employment law. And I recommend it. If you go to that Seyfarth and Shaw's website, you'll see an option where you can click and get it. Then from the viewpoint of a mediator, Steve Pearl's site, again, very good emphasis on wage and hour litigation. And if you're interested in this area of law, read your newspaper every day. Here are some sample things that are going on. The Oakland Raiders cheerleaders are suing the football team for abusive practices. Apple and Google just last week agreed to settle a case where they had surreptitiously made an agreement not to poach one another's employees. And, even the late Steve Jobs was involved in that. So read your newspaper every day. You'll see all sorts of really intriguing and significant employment law cases coming up. Finally, again here in the library, the Continuing Education of the Bar puts out an annual review. It's a roundtable discussion. You can listen to it in your car, very well done. The Judicial Council of the Jury Instructions, Volume 2, covers FEHA. If you're writing a complaint, it's very smart to go to the jury instructions and work backwards from that and use those elements in creating your complaint. If you're interested in management side, the firm Littler Mendelson has an annual book, The California Employer. If you want to buy it and you want to spend a lot of money, you're welcome to buy it. If you want to come here to the law library and borrow it for free, like I do, then you can do that. So finally, here's Charlie Chaplin in an old-fashioned workplace. Why am I in employment law? I started my career, I was a journalist. I was a newspaper reporter. And I met a man named Dero Saunders, who was an editor of Forbes magazine in New York. And a fine gentleman, great journalist, and we had lunch. And he said, there are three great themes in life, three great themes. There's love, there's war, and there's work. And writers and artists and poets spend a lot of time on the first two, love and war, and they don't really have much to say about work. But work is the essential force in our lives, and it determines our state of mind and how we relate to our spouses and our families and our friends. And I feel that if by practicing employment law, I can make the workplace more amenable, more pleasant, less hostile, then I'm part of something good, and I'm part of making American life better. And if you're interested in this field as a practitioner or in any other profession, I think you'll feel the same way. This is my contact information. It's in your handouts. I would welcome thoughts from you or stories or just staying in touch, because it's what I hear from people out there that make me a better practitioner. So with that, I'll thank those of you who are watching. I'll thank those of you for joining. Again, Nora and her team here at the library, and here's to a great weekend. Bye-bye.